Good morning to all. Today we are going to discuss one case law from the IBC, which is relating to CARP regulations and section 30 of the IBC code. As, according to this section 30, and the resolution plan has to be submitted. And according to section regulation 37-38 of the CARP regulations, the resolution plan must contain the details regarding its feasibility and viability of implementing the resolution plan. And also it should consist of the required approvals from the statutory authorities. So if these things were not present, it is not considered as a resolution plan which is in compliance with the regulations. So it is very important to comply with the regulations, CARP regulations, and plans should be submitted accordingly. So what happened in this matter? Now coming to the case law, what happened in this matter is a matter between the Greater Noida Industrial Development Authority versus Prabjit Singh Soni and others. The observation is given by the Honorable Supreme Court is that resolution plan requires closer examination. The plan envisages use of asset owned by statutory authority. This Greater Noida Industrial Development Authority has given a lease to the corporate debtor. And the corporate debtor with these lease conditions, lease are the certain terms and conditions that if you are not making the paying the rents or if there is any default, then this lease will be cancelled and it will be taken by the authorities. So this corporate debtor is defaulted and it went for this CARP process. And this Greater Noida Industrial Development Authority has submitted their claim to the resolution professional as a financial creditor, but they are not taken them as a financial creditor and they have taken this authority as an operational creditor and their amount is also reduced. So they have filed an appeal before the Honorable Supreme Court. This is the case. Let us see what is this case relating to. In the instant case, the resolution applicant, that is Greater Noida Industrial Development Authority, is a statutory authority owing the land for which a resolution plan is envisaged. The same land was provided on lease to corporate debtor subject to payment of interest as well as penal interest by reserving the right to cancel the lease and resume the demised land subject to terms and certain conditions. The corporate debtor committed a default in payment of installments and was served with a demand cum pre-cancellation notice. When the resolution plan was submitted for the consideration of the COC, the appellant, that is this authority, resolution applicant, was denied its original claim as financial creditor. Come down. But contained a lesser claim as an operational creditor. NCLT approved the resolution plan passed by the COC and same was upheld by the NCLAT. Assailing the impugned order of NCLAT, the appellant resolution applicant preferred a civil appeal before the Supreme Court. Disagreeing with the view taken by the adjudicating authorities by upholding the plan, the bench observed that as per Regulation 38, subsection 3 of CARP regulations, the resolution plan must demonstrate that firstly it is feasible and viable, and secondly it has provisions for approvals required and timeline for the same, failing which plan requires the closer examination. In the instant case, the plan received utilization of land owned by the appellant. Ordinarily, feasibility and viability of a plan are economic decisions, but best left to the commercial wisdom of COC. However, where the plan, just come down. Envisages use of land not owned by the CD but by a third party, such as appellant, which is a statutory body bound by its own rules and regulations, having statutory flavor, there has to be a closer examination of the plan's feasibility. The court also observed that when the resolution plan envisages the necessary approvals of the statutory authority, then the plan must reflect such approval as per the CARP regulations. Here on part of the CD, where there were defaults in payment of installments which allegedly resulted in rising of demand and issuance of pre-cancellation notice. In these circumstances, when the resolution plan envisages necessary approvals of statutory authority is an important aspect on which the feasibility of the plan depends. Unfortunately, the order of approval does not envisage such approvals, but neither NCLT nor NCLAT dealt with those aspects. The resolution plan did not meet all the parameters laid down in subsection 2 of section 30 of IBC read with regulations 37 and 38 of the CARP regulations 2016. We are of the considered view that the appeals of the appellant are entitled to be allowed and are accordingly allowed. The court added, accordingly, the appeals preferred by the resolution applicant are allowed and the resolution plan is sent back to the COC for resubmission after satisfying the parameters set out by the court. So this is the order passed by the Honorable Supreme Court. What has to be looked into is, you have to see the CARP regulations before submitting the resolution plan for approval by COC as well as to the NCLT. Okay, so CARP regulations clearly states what are the approvals need to be mentioned in the resolution plan. So if the resolution plan does not have these kinds of details, or it is not as per the code, then it will be sent back. Okay, this is for today. Any doubt? You can ask to me.
No, sir.
Okay. Thank you.
Thank you, sir. Thank you, everyone.
Thank you, sir.
Thank you.
Thank you, sir.
Thank you.